The river Meuse runs from France through Belgium into the Netherlands and then to the sea. Part of it follows the boundary between Belgium and the Netherlands. Belgium and the Netherlands realised early that increasing industrial use of the river could threaten its capacity, so in 1863 they concluded a treaty regarding the diversion of water from the Meuse into canals and irrigation systems to allow for the economic exploitation of the river in a controlled and sensible way. By the 1920s, the economies and industries of the two nations looked very different to how they had in the 1860s. Both countries constructed canals and irrigation systems which the other country considered to be in breach of the treaty. They attempted to renegotiate the treaty, but those negotiations ultimately failed, and the matter ended up before the Permanent Court of International Justice. The court found that neither of the nations was in breach of their obligations under the Treaty of 1863, but the case is not really remembered for that fact. The case is really significant because of the additional comments made by Judge Hudson, a judge from the United States of America. He considered whether the court was entitled to look beyond the mere words of the treaty and to apply principles of equity in determining the dispute. He said, "What are widely known as principles of equity have long been considered to constitute a part of international law, and as such they have often been applied by international tribunals. It would seem to be an important principle of equity that where two parties have assumed an identical or reciprocal obligation, one party which is engaged in a continuing non-performance of that obligation should not be permitted to take advantage of a similar non-performance of that obligation by the other party." By applying these principles, he formed the view that the Netherlands was prevented from bringing its case against Belgium because the Netherlands had already engaged in similar conduct previously, so either both of them were in breach of the treaty, or neither of them was. From this case, we confirm that principles of equity do form part of international law, but they do so on the same basis as equity in English or Australian law. The principles can fill in gaps left by the common law and statute. They cannot override those higher forms of law.